Do you understand what I'm asking?
I'm trying to understand what you're asking me.
What do you understand about what I'm asking?
You asked me to explain what I told Magistrate Fink, and I have to the best of my knowledge.
And what did you say? Let me withdraw that. What did you say to Magistrate Fink about the nature of the calls that have been received?
I don't recall much of the conversation with Magistrate Fink.
You recalled it just a few minutes ago.
Well, I'm trying to recall.
You said under oath what you told Magistrate Fink about the calls that were received.
Yes.
Do you even recall your testimony about that minutes ago?
Yes.
And what was your testimony?
About the calls that were received to Parma Police Dispatch.
Uh-huh. And what did you say about those calls to Magistrate Fink?
That people believed that this was the real page.
And that's what you told Magistrate Fink, right?
I believe so.
And that's your sworn testimony in this case about what you told him, correct?
Yes.
Under oath, correct?
Yes.
And that is different than the other two categories of calls we've talked about today, because the actual number of those was 0 on your own chart and notes here, Exhibit 910A, correct? You want to look at Exhibit 910A?
No, I don't need to.
The number of calls in which people actually believed that Mr. Novak's page was real was 0, correct?
Based on this chart and what we did, yes.
Those 7 calls are the universe of calls that we have, right?
Yes.
And that's the universe of calls that you had in your investigation, correct?
Yes.
And when you appeared before Magistrate Judge Fink, I don't know if it's a magistrate or magistrate judge, I'll call him a magistrate. When you appeared before Magistrate Fink, the actual number of calls that you had in evidence and that you had reviewed in which people believed that Mr. Novak's Facebook page was correct was 0, correct?
Yes.
And yet, you told Magistrate Fink under oath that people called believing that it was real, correct?
I may have, yes.
And then that testimony would have been false, correct?
It may have been.
All right. Now, what else did you say to Magistrate Fink that you haven't already talked about?
I don't recall.
Did you tell him about the specific content of Mr. Novak's 6 Facebook posts that we talked about today?
I don't recall.
Did you show him those posts?
I don't recall.
Did you have screenshots with you?
I don't remember.
Did you have the Facebook page with you?
I don't remember.
Did you tell him that the page was obviously a joke?
I don't recall that.
Did you tell him that no reasonable person would think this was a real Parma Police Department page based on all of the content on the page?
I had no discussion with him in regards to a reasonable person.
Well, did you tell him the opposite? That a reasonable person would think this was a genuine Parma Police Department page?
I had no discussion whatsoever with regards to a reasonable person with Magistrate Fink.
Did you raise with him any questions or concerns about Mr. Novak's First Amendment free speech rights?
No.
By seeking an arrest warrant, you were trying to initiate an arrest, correct?
Yes.
And by doing so, you were also trying to initiate the charging process, correct?
Yes.
And you were trying to initiate a prosecution, correct?
I suppose an arrest would be the start of a prosecution.
So the answer is correct.
Yes.
And otherwise, you wouldn't arrest somebody, right?
Correct.
Or try to arrest somebody, right?
Yes.
Okay. Let's take a quick break. This will be very quick.
Okay, we are back on the record. It's 5:39. Detective Connor wants to respond in greater detail to one of your questions. Go ahead, Detective.
Yes, Mr. Chandra, you'd asked me with regards to Magistrate Fink and what I recalled about that conversation. I don't recall much about that conversation. I was kind of guessing at what I may have told him, but I wouldn't lie to Magistrate Fink.
So you're changing your testimony now.
Yes.
having had a break and an opportunity to confer with your counsel, you're changing your sworn testimony.
Yes.
And so you're changing your testimony that you might have told Magistrate Judge Fink that there were people who called who were fooled about and complained about this Facebook page, correct?
No.
There were people in the category of Exhibit 910A where it said 0. You didn't represent to him that that's who was calling, right?
No, I remember very little from a short conversation 4 years ago. Very little. But I know for a fact I would not lie to Magistrate Fink.
Well, what you're talking about is what you believe to be your professional habit, correct?
I'm not certain I understand
It's
that.
your professional habit not to lie to magistrates. That's what you're saying, correct? When you say you wouldn't do something, you're testifying about your professional habit. Is that fair?
I suppose, but I know that didn't occur.
So now you know it didn't occur, right?
Yes.
But when you were testifying, you said that you told, more than once, you said under oath that you testified to Magistrate Fink under oath after he gave you the oath that there were people calling to complain about Mr. Novak's Facebook page that were fooled by it, right?
Yes, and what I was doing was, I don't recall that short conversation. I was kind of guessing at that.
Well, you know, as a person who's been a professional witness for decades, that you're not supposed to guess, right?
Yes.
And you just decided today to guess.
Well, no, sir. Fact is, we're 6+ hours into this, kind of mentally drained right now.
So you're blaming it on being mentally drained is why you said what you said about that you may have not been truthful with Magistrate Fink, right?
Correct. I was.
So do you just need to break your deposition today so we can resume when you're fresh?
No.
Well, aren't I running an even greater risk that you'll later backtrack on testimony and claim it wasn't correct because you were mentally drained?
No.
So we only risk that with respect to this testimony you're now backpedaling on, right?
No.
Object to what you may be assuming as a risk.
I'm asking you questions. Do you comprehend my questions?
Yes.
Are you too tired to answer?
No.
You too tired to answer truthfully?
No.
But you were too tired to answer truthfully with respect to that question, right?
Again, I don't recall that short conversation with Magistrate Fink. I had guessed at that particular question.
Are you having total amnesia at this moment about that conversation?
No.
So when you were testifying about that conversation, and at least twice said that you told Magistrate Fink that there were people who were calling to complain about the Facebook page that were fooled about it, when you said that, at that point, you were just testifying guesses but experiencing amnesia about the conversation, right?
It was a guess.
Did you say it was a guess at the time?
No, I don't recall saying that.
So how can I be assured that the rest of your testimony won't just be guesses?
I'm going to testify to the best of my ability.
Well, you're blaming it on fatigue. How can I be sure that the rest of your testimony won't just be guesses because you're tired?
It won't be guesses.
And you're only coming up with this explanation now. When we took a break in the deposition and left the room and you were here privately with your lawyers, you had a conversation with your lawyer about it before you changed your testimony, didn't you?
Yes.
I'm not asking about the content of that conversation. But I am saying that that conversation caused you to change your testimony, correct?
Objection. Don't answer that question.
I'm not asking about the content of the conversation, sir.
Yes, you are implicitly. Don't answer that question.
I'm asking about his own mental state. You're really instructing him not to answer about his own mental state?
I'm instructing him not to answer about what occurred in the conversation.
Were you instructed by your counsel to change your testimony, sir?
Objection. Don't answer that question as to any conversation with counsel. You know better.
after your conversation with counsel, and before I walk back in the room to resume this testimony, your recollection of the conversation with Magistrate Fink changed, correct?
Yes.
And you went from being able to describe at least some of that conversation to total amnesia about what occurred in that conversation, correct?
Objection is to that characterization. You can
I'm
answer
asking
if
you.
can.
No speaking objections, please.
I'm sorry, can you repeat the question?
I'm going to have the question read back to you because there was an improper speaking objection. Go ahead.
And he went from being able to describe at least some of that conversation to total amnesia about what occurred in that conversation, correct?
No, that's not correct. As I explained, I was guessing at that particular question.
Well, you
I don't
now,
recall
at this
that
moment-
short conversation.
I'm sorry. I'm going to have the answer read back to me, please.
No, that's not correct. As I explained, I was guessing at that particular question. I don't recall that short conversation.
Okay. At this moment now, you recall none of that conversation, correct?
No.
It's not correct.
No, I don't recall that conversation.
So now, at this moment, you have zero recollection of your conversation sworn under oath with Magistrate Fink seeking an arrest warrant for Mr. Novak, correct?
That's correct.
But when you were testifying earlier, you had some recollection of it, correct?
I was guessing at it.
You know better than to do that, correct?
Yes.
Now, why would that particular thing that you said about your testimony to Magistrate Fink, about the calls that were received by the Parma Police Department about Mr. Novak's page, why would that be your guess about what you said to Magistrate Fink?
I don't know, sir. I thought I was articulating that I didn't remember the call, and I guessed at it. I just want to make it clear that I guessed at that particular answer.
Why would you guess something you know isn't true?
I don't know.
Is it the fatigue talking?
I don't know.
That's what you blamed earlier. Have you changed your testimony on that too?
No.
So it is the fatigue talking.
During that particular question, it may have been.
So now it may have been the fatigue talking. Correct?
I believe it may have been.
All right. 1 week after Magistrate Fink signed the arrest warrant, if you could go back to looking at the Exhibit 30.
Question, including the one you've just made.
Yeah, we've asked more than once and it hasn't happened. So, all right, let's turn to, I've got a question for you based on your trial testimony. And did you reread your trial testimony at any point in
Yes.
the criminal trial? When was the last time you read that?
A couple days ago.
Okay. So it's reasonably fresh in your mind?
Reasonably.
Okay. Let's take a look at Plaintiff's Exhibit 23. Here's 2 copies of it. These are defendant's Bates numbers 17120 through 17178. Now, you testified at trial that the investigation in Mr. Novak's Facebook page prevented you from working on other cases. Do you recall that testimony?
Yes.
And do these documents that were produced to us provide information on those other cases?
I believe so, yes.
Looking at the first page, 17120, what kind of case was this?
This was 17120 was an aggravated robbery, aggravated burglary, kidnapping, having weapons under disability, illegal conveyance of drugs into a detention facility, and possession of heroin.
Was this the case you were talking about in your trial testimony, which you read a couple of days ago, involving a home invasion case where you were trying to obtain a buccal swab?
Yes.
And what are buccal swabs, just briefly?
They're basically cotton swabs, pardon me, where we take saliva, so we rub the cotton swab in the mouth from each side of the mouth, and we submit those to perhaps BCI, perhaps the medical examiner's office, to obtain DNA.
Okay, does this report from you, responsive to our document requests on the cases that you were working on, show a plan to take buccal swabs on March 2nd, 2016?
No, it shows a conversation with the defense attorney on March 2nd, 2016.
So nothing in this report shows you had actually planned to take buccal swabs on March 2nd, 2016, the day you were investigating Mr. Novak, correct?
No,
I'm not correct?
no, you're correct.
Thank you. And defendants 1726, if you could turn to that page, Bates numbered that way. This is still in Plaintiff's Exhibit 23. It shows that you received a call from Gill's attorney on March 2nd, 2016. Was that true?
Correct.
That's why you wrote it down, right?
Yes,
But you made arrangements to meet at the county jail on March 4th, 2016 to obtain the buccal swabs, right?
that's correct, because I could not attend the pretrial on March 2nd, 2016.
Well, but it wasn't previously scheduled for March 2nd, correct?
The pretrial was scheduled for March 2nd, 2016.
Meeting with each other to do the buccal swab?
Yes, this was quite important, the buccal swabs in this particular case.
Well, but it doesn't say that that's when it was scheduled, correct?
Well, sir, I didn't write down each and every pretrial we had in this case.
So and you didn't call Gill's attorney to reschedule. She called you on March 2nd to pick the date to obtain buccal swabs, correct?
Correct, because I had to cancel coming down on March 2nd.
Where does it say that you canceled it on March 2nd?
It does not.
Your sworn testimony during Mr. Novak's criminal trial that you were scheduled to obtain buccal swabs already on March 2nd, 2016 was false, correct?
Absolutely not.
Was there anything you were unable to do in this case before you because of the Novak investigation?
On March 2nd, yes.
Anything else beyond that?
After March 2nd, no.
On this case.
Why-
Is that what you're asking about?
Yeah, I'm saying with respect to this case in front of you,
Gill's new attorney.
Gill's attorney called you, right,
Correct.
to reschedule it. How would Gill's attorney have known that you were somehow too busy on March 2nd to do what had previously been planned?
Because I had a conversation with the prosecutor in this case because of the refusal of a search warrant. So this was a high priority case, and I had many conversations with the prosecutor in this case.
But Mr. Novak's investigation, the investigation of Mr. Novak, became a higher priority than this very serious case, correct?
On March 2nd, yes.
And again, the records don't reflect that anything was scheduled, correct? For March 2nd?
In my report, no.
They do reflect that it was Gill's attorney who called you to reschedule, though, correct?
Yes.
Now, why did you not produce this in response to public records requests regarding the Novak investigation?
I believe it was produced. I don't know, though.
If I represent to you it was not produced in response to public records requests asking for all documents relevant to the Novak investigation, but was only produced in the discovery in this case, would you have any reason to dispute that?
I don't know, sir.
Now, you didn't produce this to Mr. Novak's counsel or to the prosecutors to give to Mr. Novak's counsel as Brady evidence in connection with the trial where Mr. Novak was being tried?
No.
Actually, you can answer.
No.
Now, given what an important case this was, you could have asked Lieutenant Riley to stop working on the Novak investigation and instead to focus on this case, correct?
I don't know about that.
Well, this case was far more serious than anything Mr. Novak had done, correct?
Yes.
And you could have asked to focus on this case, correct?
I don't know.
Well, wouldn't you agree that it's probably more important to rape victims that your department prioritize them rather than this Facebook page?
Yes.
All right. Let's take a look at Exhibit 20.
1 minute left? How-
All right. Let's go off the record and grab Exhibit 20.
Back on record?
Sure.
Amy Berry, will you alert us when 7 hours is up?
All right. Other than what you've already testified about today, right? Did you receive any First Amendment training in connection with your job associated with anonymous speech? Mr. Novak's right to be anonymous, for example. Yes or no?
With regards to anonymous speech, I don't recall that.
The answer is no. You've never received such training from
I
the
don't
city of
recall
Parma?
with regards to anonymous speech.
Meaning you could have, you've just forgotten?
I don't recall getting training in the First Amendment with
Okay,
regards to anonymous speech.
Do you recall before March 2016 getting any First Amendment training at all from
Yes.
the city of Parma?